introductions so that you know who you're talking to. We've got a couple of members who are not in, we have a small committee and we're down a couple of folks today, so just the six of us. But we will, everything is recorded. We'll share what we learned from you with our colleagues. I'm David Durfee. I represent Bennington 3, which is Shaftesbury, Sunderland, and Glastonbury. And we'll just go around here.
I'm Leland Morgan. I represent Grand Isle County and the town of, part of the town of Milton.
Judge Lipsky, Lamoille 1 district that represents Stowe.
Richard Nelson, Orleans 1, Derby.
Michelle Boslin, Wyndham 3, which is Westminster, Rockingham, and Brookline.
Hi, John. John O'Brien, Windsor Orange 1. That's we're up in the Tongue.
And then Sonia, committee assistant. Our other two folks aren't going to be joining us. Yeah, that's fine. With that, we've already spent some time earlier today taking some testimony S45. And if you would like to introduce yourself and explain what your expertise is, and then we'd be happy to hear your thoughts.
For the record, my name is John Echevarria. I wonder, John, whether we should disclose that you and I are neighbors. If we share a boundary, and we've thankfully never had any nuisance or trespass issue arise between us. But
His sheep haven't run onto your property or anything?
well, my cows, have gone onto
That's on our property, yes.
on another neighbor's property, but not John's.
It is not uncommon for two people in this room to be neighbors, as it turns out, or have some close connection.
That brings up an interesting question too, because John lives in Stratford, so not my district, but the farm he owns is next to me. So that I don't know if owning property makes you a constituent.
Yeah.
I don't vote for you.
Trade.
Right, that's true.
Representative Boswell, would you mind shutting the door?
Okay, so again, my name is John Echevarria, and I'm a professor at the Vermont Law School. I'm obviously not here on behalf of the law school, but speaking on my own behalf. I've been a practicing lawyer for years, and my particular specialties, as it happens, have been in water law and in property law. And I've taught both of those subjects at the law school, and I've been involved in litigation matters and written extensively on all those issues. Particularly property rights, but also water. So I have a considerable amount of background. Not that I may err, and people will contradict me, and people will be right in contradicting me. But I have a lot of experience. I apologize. I submitted some written testimony, and as the saying goes, if I'd had more time, it would have been shorter. I assume you'll put it in the archives and it'll be available as a resource, but it's lengthy. I'm not intending to read it today and bore me and yourselves to death. My basic theme is to caution you about including trespass in the right to farm legislation in this round of amendments, primarily because trespass is a particularly severe form of interference with the neighbor's property, but also because it raised distinct constitutional issues having to do with the takings of private property. And my concern is that if the legislation that exists today were expanded beyond nuisance, the traditional focus of right to farm legislation to include trespass, the law would routinely have the effect of resulting in unconstitutional violations of neighbors' private property rights. There's a lot of law to talk about, and that's my expertise. But I described this issue to a neighbor of mine, my friend Mark, who changes my tires every mud season, or better yet, at the end of mud season. And I explained to him this legislative issue, and his quote was, it's just common sense that you shouldn't dump your water on your neighbor's land. And I thought, I don't know why I worry about all the technical details, because that sort of sums up what I think the principle ought to be. And I think it's reflected, it's a common sense idea, and I think it's reflected in how neighbors generally treat each other in Vermont, and it's also reflected in the law. So to begin, I thought I'd talk about two legal doctrines, which I think are sort of essential background and interesting. The first one is the law of surface water drainage, which is a very obscure area of the law. And as law professors, we never know whether to teach it in property or in water law or in tort law, because it's very hard to label it. But the content of it is very clear in Vermont and has been frequently applied. And it basically establishes there are a set of reciprocal rights and duties between neighboring landowners, one who are in one with a higher on the slope and one lower on the slope. And basically, the upper slope landowner has a right and indeed a duty to let all the water that naturally flows across their property and that naturally would flow across the boundary to the lower property owner, to let the water pass there. And the lower property owner has both a right to receive that water and a duty to accept it, to not try to interfere with it. So basically, it's the principle of allowing the natural flow of water as it's wont to flow downslope across property lines. Now, that may mean in some cases, a little bit of water, if there's a drought condition, or it could be a whole lot of water. And it could even be a destructive amount of water. But that's within the scope of the doctrine, because the lower owner has to accept whatever naturally is going to flow down. But the basic rule is subject to this important qualification that the upslope owner cannot artificially increase the flow of water or change the direction of the flow of water in a way that it causes harm to the downstream owner. And if that occurs, and there are many cases about this over the decades, the lower owner is entitled to sue for an injunction or sue for damages. And the artificial modification of water flow can occur in a whole variety of ways. It could be a berm, it could be a ditch, it could be a culvert, or in the Erie Point case that you all know about, it could be tile drains. So that's sort of a basic background principle of water law, and you can think of it it's a freestanding doctrine, but it's really sort of a specialized version of trespass. It's trespass. You can't trespass with extra water flowing down to your neighbor downslope. The other thing I want to talk about is the takings doctrine, which is rooted in the takings clause of the Fifth Amendment of the U.S. Constitution and Chapter 1, Article 2 of the Vermont Constitution, which are basically say you can't take private property unless as a necessity and paying just compensation. And they're generally interpreted more or less the same way. Although Vermont has particular pride of place when it comes to private property rights protection. As you all know your history, Vermont was born in a property rights dispute, right? Trying to defend the land grants in Vermont from those dastardly folks in New York who were trying to steal our land grants. And more than any other state in the nation, Vermont was birthed in a property rights conflict. As a result, the Constitution of 1777, when Vermont was still a republic, included the first takings clause ever in North America. It subsequently served as the model for the federal takings clause and the takings clauses in other constitutions in other states. And the Vermont Supreme Court has suggested in very recent decisions that this tradition and history of concern about private property rights is a distinguishing characteristic in Vermont and leads Vermont in certain circumstances to be more protective of private property rights than other states, and maybe at some point to interpret its takings clause to be more protective than the federal takings clause. But that's an aside, an interesting aside, but an irrelevant aside. The important point is that takings doctrine, as interpreted by the Vermont Supreme Court and the U.S. Supreme Court, draws an important distinction between different kinds of government interferences or government authorized interferences with private property. On the one hand, there are restrictions on the use of property. Think zoning laws or floodplain regulations. The government passes a law and says you can't build something, or you can't build as many things as you want to build. That's a regulatory restriction on the use of property. And the Supreme Court and the Vermont Supreme Court have said, Those kinds of regulations are evaluated under a very complex multi-factor analysis that takes everything in the world into consideration, with the result that it's very hard to figure out in advance how those cases will come out, and the plaintiffs generally lose. Then there are this separate category of governmental impacts on private property, which involve physical invasions or physical occupations, where the government comes onto your property. People come onto your property. They put a well on your property. They drive trucks on your property. They build a dam and flood your property. Those are in a special category where the court has said if the activity fits into that category, then the government has a clear and categorical obligation to provide compensation. And the Supreme Court has said that the reason we have this special rule for physical occupations is because the right to exclude is one of the most treasured sticks in the owner's bundle of property rights, that it's just more valuable. And I think that accords with a lot of our instincts about property rights. It's one thing for the government to send us a letter saying, only two houses per 3 acres. It's another thing for government agents to march onto the property. In any event, the Supreme Court, based in the idea that the right to exclude is special, has said, and that's the third rail of taking jurisprudence. So when you do that, when you hit that, it's almost always a taking. And importantly, this doctrine applies when the government invades or occupies property, or the government says Carol or Harry can invade the property. Third parties can occupy the property. And the Supreme Court has said that this rule applies regardless of whether the invasion is permanent or temporary, continuous, or intermittent. Very broad, robust doctrine. And this has been applied in all sorts of contexts to the government flew military aircraft very, very low through private airspace above private land. That was a taking. Allowed boats, the public in boats, travel over a private pond. That was a taking. Required apartment building owners in New York to accept wires that the cable companies wanted to install without apartment owner permission. That was a physical occupation and a taking. Or an order saying the public can pass across private beachfront property. And as I say, and not surprisingly, the doctrines have applied in the context of water. So in one of the very earliest Supreme Court cases, the court said, the state of Wisconsin authorized the utility to build a dam. The dam created a reservoir, it flooded the farmer's property. The farmer's entitled to compensation. Much more recently, in a case coming out of Arkansas, the Army Corps of Engineers adopted a very different regime for governing a dam, with the result that there was extreme seasonal flooding many miles downstream that invaded the property, caused substantial property damage, and the court said that was a taking. So there are some minor exceptions to that doctrine, but I'm going to leave those aside for the moment. I've just covered them in my taking. There's an essentially universal general rule of physical occupation is going to end up being a taking. Now, the question is, how does that apply to right to farm legislation? So on the one, the traditional focus of right to farm legislation is nuisances, right? And a nuisance is defined as, generally speaking, as a non-trespassory invasion of another's interest in the private use and enjoyment of land. In other words, you're not invading, you're not occupying, you're doing something next door that causes odors, causes noise, it interferes with an owner's use and enjoyment of their property, but it doesn't invade it. And if you have an immunity from nuisance claims, as the traditional right to farm legislation contains, that basically means that the person causing the nuisance is privileged to continue with the nuisance and to continue interfering with the use of the neighbor, interfere with the reasonable use of the neighbor's land because the privilege has been granted. That kind of immunity amounts to a restriction on the use of the neighbor's property. And so I think, and I think most people think, should be evaluated as a regulatory take, as the first category of takings I identify, where you look at all the factors, you do a lot of balancing, and you almost always conclude that there's not a taking. And that is the general law across the country. There's one famous Iowa case that found that the Iowa immunity right to farm legislation, which included immunity from trespass claims, was a taking, But I don't think that case is rightly decided. Most state courts that have looked at it have disagreed. And most state courts that have looked at this issue have said that trespass provisions in right to farm legislation are not takings.
Sorry, trespass or nuisance?
Did I say nuisance? Did I say, I'm sorry, did I misspeak?
Trespass, and I
Thank you.
just want to be sure.
No, I'm trying to, yes. So now I want to move to trespass. And in my view, that if the law were extended to trespass, that would in effect mean that somebody who was trespassing, say with water, who could now respond and seek an injunction or damages, would not be able to do that. And in effect, the law would confer a privilege on the person who is causing the flooding to continue to do that, which would result in a government authorized physical invasion of the property downstream. And so I think addition of trespass language would trigger the per se categorical rule for physical takings. As I say, the legislation would in effect affirmatively allow farmers to engage in trespasses. And then in cases like Erie Point or other similar cases, if the immunity applied and the person could not bring a claim, an injunction or damage action anymore, they could turn around and they would suffer a taking of their private property. So the question is, what would happen if the legislation were amended in this way to include trespass? Well, some people would sue, and in the Erie Farms case, apparently there's owners with substantial wherewithal who have brought suit, and maybe if they were in a similar situation in the future and they were barred from bringing a trespass action, they would bring a takings action, right? And there would be some of those, and some of those could be costly to the state. They certainly consume a lot of the Attorney General's time and would likely succeed. But I think that the committee might be more concerned about the fact that most people couldn't sue for a taking of their private property. In other words, they would suffer an invasion of their property. And if the legislations authorize that, they would suffer an unconstitutional violation of their private property rights as a result of the legislation. But unless they've got, $30,000, $40,000 kicking around in the bank account to fund a lawsuit, they can't do anything about it. And so I'm more concerned about that category of people than those who can vindicate their constitutional rights. Now, I've heard it said that, but there are no reported cases where it has been held that extending right to farm legislation to trespass results in a taking. And I concede that's true so far as I know. My response to that would be to say, but there are only 2 states in the nation that have taken the fairly radical step of including trespass in their right to farm legislation. And so not surprisingly, in those 2 states, we haven't had any litigation. I think the more important point is that the general analysis that I've laid out about when authorized occupations, authorized flooding result in takings would support the conclusion that authorizing that kind of flooding would be a violation of private property rights and would give rise eventually to successful takings claims. Now, another point I've heard raised is that the concern about takings could be addressed by adding language to the amended right to farm legislation, stating that the immunity for trespass claims wouldn't apply if recognizing the immunity would result in a constitutional taking. And I think that's a very bad idea. I mean, it's a bad idea for the following reason. That would mean that the downslope property owner seeking to vindicate their property rights, to assert that there's been a trespass on their property, would have to prove not only that they've suffered a trespass, but establish a valid takings claim. So they have to sort of, the burdened landowner would have sort of twice the litigation burden. But perhaps more importantly, I think it's nonsensical because in the vast majority of cases where the government authorized flooding of a kind, substantial, persistent flooding of a kind that would give rise to a claim, there is a take. It's always a take. I mean, you never can say always in the law, but it's pretty much always a taking. And so there's no point in requiring the landowner to say, oh, this would be a taking. No, it will always be a taking. And the legislature can recognize that and doesn't need to deal with it by providing sort of an exception. That was what I had to say. I guess the other thing I wanted to say is that the right to farm legislation, I mean, it sets rules and boundaries for litigation. You know, who's going to win, who's going to lose, what are they going to have to prove, what are they going to have to, what defenses can they raise? But it also just sets the tone. It sort of establishes the rules of the road for living in Vermont. I come back to Mark's comment, which is just common sense that you don't dump your water on your neighbor's land. And it seems to me that is a good principle for the law to announce and to repeat and for people to live by. And so, you know, regardless of whether anybody's going to sue anybody or whether anybody's ever going to hire a lawyer, it's just a good principle. So time permitting, I was going to just add, if it's all right with you, Mr. Chair, to add a few words about the latest version of the draft of S45 that came out of the House Judiciary Committee.
Yes, we certainly have time. Before you do that, let me just see if anybody had a question that you wanted to ask now. And we'll also have time for questions afterwards. Representative O'Brien.
So how does eminent domain work then, John? Can it be, you know, both something, say the interstates in Vermont, would the government has to go ahead and say, they're going to be takings here, we recognize that and we'll compensate you, but there's also almost a reverse of that sometimes, or it's in reverse rather, where the government does something on your land and then there's either a lawsuit or the government at some point admits that, yes, we've done something, we've trespassed.
Right. I mean, it is right. So when the government is pretty sure it's going to take land, the responsible thing is to say, hey, we're taking your land. And here's a letter announcing we're taking the land. And we're offering you $250 in compensation. Then the owner can say, I want $350 and so on. But yes, I mean, in a variety of contexts, either by mistake or overreach, the government takes some action and they've triggered takings liability, but they haven't admitted it. And somebody might go to court and litigate the question of whether or not there's a taking. And if there's a taking, then the court says, well, you have, the plaintiff is entitled to recovery on an inverse condemnation claim. That they had, instead of the government starting the action as they do in an eminent domain proceeding, in an inverse condemnation action, the landowner has to bring the action and say, hey, you've taken my land. And if they're successful in establishing how the taking it occurred, then they receive the same just compensation that they would receive if the government had done the right thing to begin with and initiated an eminent domain proceeding.
Are there weights then, depending whether it's federal, state, or municipal?
Weights?
As far as, it doesn't matter what the level of government is.
No, it doesn't. And the federal government and the states and local governments are sued for inverse condemnation all the time. And each level of government also has some authority defined by statute to exercise eminent domain. So in the law is, some people have said the law ought to vary depending on what level of jurisdiction you're at, but that's not an idea that the courts have embraced. It's the same rule for everybody, every level of government.
And I just wonder if the law of surface water, is that mostly common law now in case law, or is it some authorities is it in statute now?
I think it's almost, as far as I know, it's purely common law. It's a longstanding common law doctrine, and you know, every state has some variation on it, and Vermont has its own, and it's been in place for years and years and years.
And we did hear, you made a reference to this. We did hear earlier in testimony that there were in the two states that do include trespass or right to trespass in their right to farm laws, that there haven't been any claims of takings. Do you know how long those states have had those laws in the books?
That's a good question. I'll check for you. I would suspect they're fairly new, but I don't know because it's sort of, I mean, right to farm laws almost by definition relate to nuisances. And so to my understanding, adding trespass is sort of a novelty, but I'll get the answer to your question.
Thank you. Representative Nelson?
Yeah, thank you, Jim. John, okay, so I understand the way Dutch Council wrote this law for us, and it's been around for quite a few years. Senator Starr started this years ago. Puts us right in the middle of the pack of the 50 states, essentially. There's some that are more favorable to farming. We have one of the worst ones in the state now. In a state that is more dependent on agriculture per capita than any other state in the country. So the way I understood it, this was kind of in the middle of the pack. I will check, but I'm pretty sure I can't drain a field via ditch or drainage pipe with acceptable ag practices or required ag practices and adversely impact my neighbor's land downslope from like putting a ditch in or putting in drainage pipe. I can't adversely impact, but I'm going to check how that applies.
That's built into the management practices.
Yeah.
I wouldn't be surprised.
I'm going to check into it because I think it is.
Yeah, I can't comment on the strength or weakness of this proposal relative to other states. I mean, I have not focused on the nuisance provisions, which is sort of a separate category. And you know, a major part of this has to do with change of this bill addresses changing the standards for allowing someone to raise an immunity from a nuisance claim. And I don't know how it compares to the rest of the country. I'm just focusing on the addition of trespass. And I think on that, if my understanding is that, again, only 2 states have done that, so that Vermont would be joining a set of outlier jurisdictions. I understand that no state in the Northeast, none of the New England states have taken a similar measure. So that would, adding trespass would, as I understand, put Vermont on the edge in this region.
Yeah. And didn't judiciary strike out trespass already?
Well, I can
Get to that I think, in a minute. Yeah.
I'll get into that.
Okay, thank you.
Before we do, I had one other question, and that we've come to understand now that trespass in this context means something other than physically walking onto someone's land, which, you know, colloquially, when you think about trespass, we think about what that means. And now we've learned that, you know, in this context, sending unwanted water onto someone's land constitutes trespass. Are there other, just thinking about it in terms of agriculture and farming, are there any other obvious ways that we should be thinking about what would that mean to be trespassing?
Well, I've wondered about that, and those who are actually involved in agriculture could correct me if this is an off-the-wall suggestion, but I know there are situations where people are uncertain about where their boundaries are, or they're in a dispute about where their boundaries are, and people occupy land that the neighbor thinks is their land, right? And so that there's a trespass. It could involve putting cows on the property. It could involve plowing property. It could involve storing equipment on property. I mean, that would be a sort of intuitively more obvious kind of trespass than flooding. And you know, one wonders, would this step, the Senate version of S45, by immunizing trespass, create an immunity for those kinds of trespasses? I mean, it's hard to imagine that anyone would want, want to authorize those kinds, but, you know, trespass is a broad term, and that's the, uh, pursuing the inquiry that you raised, that's the example I could come up with of what kind of trespass that might occur.
It's not generally acceptable to hog your neighbor's land. They tend to get a little snarky if your 82-year-old father runs too close to the boundary line, because I've had to go back and fix it. Just saying. Yeah.
I guess my question is, I understand that completely,
Yeah.
and I just wonder if there might be situations where there's simply a longstanding disagreement about where the boundary
You know,
is.
then you hire a surveyor to get it ironed out.
Or in some cases, people just say, no, it's my land, and I don't know.
You survey it. I've got to do that a couple places.
Thank you for the answer, and then Representative O'Brien, and then Representative.
I just wondered apropos of what's going on now, would say if ICE takes farm workers away and it's shown to be, you know, the workers were doing nothing wrong, they were here legally, could that be a takings?
Well, there's a, you know, one of the exceptions to the physical occupation doctrine is a privileged entry onto private property by law enforcement officers for the purposes of executing an arrest warrant or a search warrant, is authorized. And I suspect that would apply even if there were some defect in the warrant. So I think it would be, I've never heard of anybody claiming that an execution of a warrant resulted in the taking, but
These are unusual times.
these are unusual times.
Representative Lipsky.
Yeah, I'm gonna go back, Professor, you really went deep into my earlier life about the natural flow of water. And I'm gonna go back less than 50 years, maybe 45 years. I was a selectman in a rural town, and a landowner wanted to block off the town culvert on a dirt road because he felt it was damaging his land. And he was wealthy and angry. So
He wanted to block a
a culvert
culvert.
that took water from an uphill ditch at a 35-degree angle and discharged it on the downhill edge of the road. And I recall our council said, we, in this case, the town, had a right by prescription that had been discharging for X period of time, and that downs have, so I'm really using you as, is there such a thing in law of a right by prescription that you've ever heard of, being a professor?
Well, sure. I mean, you know, prescriptive rights are a rite of passage that begins as a trespass, but then evolves into a vested right by virtue of having been openly and continued for a sufficient number of years.
So in this case of a farmer that's upslope, and has been pointed out here before, water flows downhill, would they possibly have a right prescriptive?
So if they artificially increase the flow of water, but they did it for 20 years, would they have acquired a right to do that? I'd have to go research. I mean, it's certainly a very plausible theory, and I don't know the.
And then I just wanted to allow that you're not the first witness here that cautioned us about the relationship between trespass and taking. So I think everyone here is all ears.
One of the peculiarities of Vermont law is that if towns manage their roads and culverts in their roads in a way that the water flows in a harmful way downstream, the town can be held financially liable. Towns enjoy general immunity from liability for all sorts of things, but at least as far back as I know, in the mid-19th century, the Vermont Supreme Court said, if towns mess up and allow water to allow a road to interrupt the natural flow in a way that's harmful, the town can be held liable. I don't know if there are many cases like the issue has arisen in recent times.
Would you like to continue then with looking at the latest version of the bill that the Judiciary Committee was working with?
Right. So I think there's been sort of some evolution in the legislation, as I understand it. I want you to, I follow this a little bit, and I don't generally follow what goes on in the Vermont legislature. And if I see something that concerns me, I drive up here and, try to volunteer. But I read about the concern that some people expressed about trespass. And I said, I think that's a takings issue. And they go, we hadn't thought about that. Well, why don't you want to come up here? So that's how I got involved in this issue. But the S4 S45, as it passed the Senate, included a modified nuisance immunity and trespass. Right, and then and there were concerns expressed at the time about trespass, that was a novel provision, and that it threatened serious infringement on neighbors' property rights. Then it went to the House Judiciary Committee, and there was a great deal of opposition against the inclusion of trespass. And it was recommended that the House Judiciary Committee remove the trespass provision. And I gave testimony, and I sort of a similar to this testimony, in which I said, I think that if the law were amended to include trespass, that would result in routine, regular, more or less continuous unconstitutional violations of people's property rights if they took advantage of this immunity for trespass. And that is, so it raised a really serious private property rights issue. A number of anyway, my sense is that members of the committee, including the chair, were noted that and determined to remove trespass from the bill. And I think every version of S45 in the House has not had an explicit provision for trespass. Right? The concern is that over time, as the bill has been worked on in the House, language has been added that is a little confusing, but seems to reintroduce nuisance back into the bill in a sort of a subtle way.
Trespass?
Reintroduces, trespass. Thank you for the corrections. Reintroduces trespass into the legislation, and thereby sort of raising again the concerns that were raised in opposition to the express inclusion of trespass, that it would authorize a particularly egregious form of invasion of a neighbor's property, and it would result in routine violations of private property rights. The two provisions that were particular concern were the definition of nuisance, which is at you all have the access to the bill right in front of you, 5752(4). States that a nuisance means any interference with reasonable use and enjoyment of land, including interference from smoke, odors, particulate matters, dust, noise, or vibration. Nuisance, as used in this chapter, includes all claims that meet the requirements of this definition, regardless of whether a complainant designates a claim as brought in nuisance, negligence, trespass, or any other area of law or equity. And the concern is that someone would bring a trespass, right? It would be a trespass claim. They'd be complaining of an entry, right? But they would also be claiming harm. They might be claiming an interference with the reasonable use and enjoyment of their property as a result of the trespass. And reading this definition literally, if there's an immunity from nuisance claims, then what this suggests is if somebody is really bringing a trespass claim and they're alleging injury, that the response from the defendant could be, Well, that just fits into the nuisance category, and the nuisance immunity applies. So I think what this language allows is it allows, well, it simply allows trespass claims to be brought in by the back door and then relabeled as nuisance claims and then barred. That would be the concern. The traditional definition of a nuisance is a non-trespassory invasion of another's interest in their land. That is, non-trespassory, fancy word for no entry, just odors, noise, or maybe particles wafting, harming the neighbor. And that's a trespass. And if the intent is to focus the legislation on traditional nuisances and bolster the traditional immunity against nuisance claims, then I think the proper course would be to stick to a traditional definition of nuisance and to shy away from this one, which, as I say, seems to bring trespass claims back in through the back door. It would, at a minimum, create a lot of confusion and be fodder for a lot of litigation. That would be an evil in itself. The other provision that's problematic is, and this is harder to talk about, is the language in section 5752.5.
That's the next section.
The next section, okay, which is the offering alternative definition. This is all in the definition section. And subsection 5 in the definition sections offers up alternative definitions. One for a 25-year, 24-hour rainfall event, and then secondly, of an annual exceedance probability. But then this definition comes home to roost, so to speak, in section 5753D, which says that I don't have my. Thank you. It says, in order to assert a nuisance protection under this chapter, a person conducting an agricultural activity shall demonstrate the person is in good standing. A person may, no, is that it? Sorry, no, that's the nuisance, but I'm looking for the,
Bottom of page 8.
This is page 5, yeah.
well, so bottom of page 6 and top of page 7.
I'm sorry, bottom of page 6. Yeah.
The nuisance protection provided for under subsection A of this section shall not affect the right of any person to recover for any injuries or damages sustained by the person due to an agricultural activity. And then skipping 1, going directly to 2, causing runoff to or flooding of the person's land unless the runoff or flooding was caused by a 25-year, 24-hour or larger rainfall event. So it says that anyone can sue, that this nuisance protection will not bar someone for suing for injuries due to an agricultural activity causing runoff or flooding, except in some cases they can, if it's a lot of flooding. But flooding is trespass. So providing, it doesn't say whenever there's it's not a blanket permission to sue over flooding, but it's a partial permission to sue over flooding. So it partially reintroduces nuisance. But I think this would be sort of just impossibly difficult to apply. And I don't really understand the notion of keying this to extreme flooding events. As I say, under the law of drainage, there are rights and responsibilities between landowners, and the water flows downhill and has to be allowed to flow downhill. And if nature delivers a whole lot of water upstream, a whole lot of water is going to flow downstream. And no matter whether it's a torrent or a middling amount of water, or you're in the middle of a drought and there's hardly any water, the law remains the same. And there's no liability one way or another. The only thing that causes liability if somebody artificially increases the flow of water. on top of a flood, on top of a middling amount of water, or on top of a dribble. It's the artificial increase that invades the rights of the downstream owner. So I guess I don't understand this idea of that immunity would or would not apply depending on whether there was a lot of flood water, because that's not consistent with my understanding of how the laws operates.
Representative Nelson.
So you're saying this section isn't really necessary as long as someone doesn't divert a brook or put a, most fields now in the state have ditches or whatnot because they meet to a road and stuff, and there's a culvert someplace that flows underneath a road and the water course goes as it is. So if someone doesn't go and alter that ditch because they want to join, say they have 2 10-acre fields divided by a ditch and it crosses the road here, they can't fill that ditch and create a ditch further down the road and send it to a new location. Okay,
Now,
I'm picking up what you're laying down. Thank you.
I mean, I'm getting a little bit, you go around the countryside and you see developments and on the side of the development, there's a stormwater base. There's sort of a great big hole in the ground with lawn in it, right? And and I think those are required in subdivision regulations and through permitting process, but I think their foundation is in the law of surface drainage. That if you have 20 acres and you're building 20 houses on it, you're going to increase the surface flow of the water. And as the developer or the subsequent owners, there's possible liability to people downstream if the velocity or force of the water has been changed. And the purpose of those drainage ditches, of those drainage basins, is to capture the water and let it percolate into the ground on site. And that's how that's dealt with. I don't know. In the farming context, I understand there's sometimes a real value in trying to get water off the field and maybe get more water off the field than they used to. And I think that can be accomplished if you can avoid impacting someone downstream. Another possibility, I don't know how feasible this is in the agricultural context, is to create those kind of drainage basins. And I know that might mean giving up some land that would otherwise be used more productively, but it would be a way of sort of providing for infiltration on the property. And the other thing is there's prescription, and there's also just buying flowage rights. The United States has flowage easements all up and down the Mississippi River. And when there's too much water and there's this Mississippi River and New Orleans is at risk of flooding, they blow a dike or they open a gate and water floods into an agricultural field, which is subject to a flowage easement that the United States has purchased. And they're private flowage easements. And so one, method consistent with the law, and and maybe this is another funding opportunity for the Department of Agriculture, is to provide for the creation of those kinds of easements. And because some people downstream will say, I really don't like my land being flooded, but if I got some money for it, I might feel different.
Would that require statutory changes, or could a private arrangement be worked out?
I don't think there's any bar to a purely private arrangement.
Representative O'Brien?
John, I just wonder if you could give us clarity. I'm thinking about, if you think of a Venn diagram where nuisance and trespass somewhat can overlap, so maybe a plaintiff could bring either. So for example, on your property, like your mental health, is that generally, if that's affected by your neighbor doing something, is that potentially a trespass, or is it a nuisance, like a wind farm, say, next door, and the whir of the blades give me headaches 24/7? Does it immediately fall into a nuisance, or there's certain things like your mental health, can it be a trespass too?
Well, the law is not all that clear, but I think the better modern view is this: that there can be injuries as a result of trespass. There can be injuries as a result of nuisance, and the injuries might be very similar. But what is different is the character of the action giving rise to liability. That a trespass, by definition, involves entry. It means coming onto the property. People, wires, boats, planes, equipment, water, crossing the boundary line and being and occupying, invading the property. That's a trespass. And then, of course, it's a trespass when you're allowed to come on the property. Then the owner says, that was nice, but now you got to go, right? And the person doesn't go. Then it turns into a trespass because they're remaining on the property. A nuisance, on the other hand, is, as I say, the conventional modern definition is a non-trespassory invasion. Nothing is coming across the property line. It's just that, and it's a somewhat artificial distinction, but it's noise and odors, and then particulates. So this sort of weird boundary issue is a particulate. If it wafts across the boundary line, is that invading the property, or is that just an interference with a non-trespassory interference with use and enjoyment? So I think that in order to avoid the authorizing trespasses and in order to avoid the violating people's private property rights, that the committee of the legislature be well advised to keep draw a sharp line between nuisance and trespass, and not muddle them and say, the trespasses are one thing, we're dealing with them, but if it's invasions, that's something else.
Because I could see this being a law that things like odors, right, they're
Odors are,
molecules or sound waves are crossing boundary rock, so it's interesting how it must get parsed in this way.
odors, I think, whatever, I understand they're molecules. In order to smell something, there must be a molecule. The molecule must have invaded the space. That's not what, I don't believe any court has ever said that. An odor can be a nuisance, but it's not a trespass.
Getting back to, I don't know if you had more you wanted to cover, but
No, that's really it.
just then back briefly on the 25-year flood language that was added here. The way that I'm reading this and trying to envision the work that the committee was doing, they had made the change to nuisance definition to somehow possibly include trespass. And then this language says, but the protection provided shall not affect the right of any person to recover damages sustained by the person due to an agricultural activity causing runoff or flooding the person's land. So it's sort of saying, we're going to have trespass, but specifically water is not going to qualify you here. You don't get a pass for water. But then we're imagining the 25-year flood, and that will be okay. So sequentially,
If you focus on the language, unless there's a flood that meets those criteria caused by, unless the runoff or flooding was caused by a 25-year, 24-hour or larger rainfall event.
yeah,
In other words, not caused by the agricultural operator,
right.
caused by, so it's a very confusing. It says you can still sue for flooding caused by the agricultural operator. That's the big principle. Flooding or runoff caused by the agricultural operator, unless the flooding was caused by a big flood, presumably a natural flood. But that exception doesn't fit into the larger category. So I guess the final point my written testimony is I don't think this is coherent. I don't think this parses.
Yeah, I think that if I'm
First.
whether it's coherent or not, but it feels like, based on everything you've said over the past hour, that the natural flow of water, whether it's a 25-year flood or a 100-year flood, has nothing, won't be ever a cause for a trespass case.
Exactly.
Yeah. And that also the only idea of trespass that seems to be applicable here is water. So if earlier
Unless we're talking about this.
unless we're talking about that, but if we feel that we're not, if we've established that it's really just water, then this new definition of nuisance, which seeks somehow to include trespass, but trespass doesn't include water, it doesn't seem to follow, based on everything you've told us.
Thank you very much.
That's, and
You sound
I realize
better
that
than
wasn't a question,
sure than I was.
I just wanted to be sure that I'm following you
Yes,
correctly.
absolutely.
But it makes sense to me. I mean, I know I can't go out and put a big diversion, brand new diversion ditch someplace and then launch it somehow under the road or launch it across my neighbor's land without making an agreement with them or of some way or sort. I would take that as common sense.
So I should just say before we wrap up, at least some of the conversation involving water involves drain tilage. So we're going to hear more about that and later in the week. But just want to be clear again that if the source of the water or the source of the trespassing water is the result of drain tiling, that's not, we shouldn't be thinking about that as a special case that deserves special treatment.
Oh, it just may be a big issue because it's recognized currently or in this bill as an accepted or a recognized agricultural practice. And I guess UVM is promoting it to some extent and some farmers are adopting it and it has an economic appeal. So it creates a challenge. But I think there's no question that it's an activity that artificially increases instead of the water seeping into the ground. It's put on an express train to the boundary of the property and downstream. So it creates the problem that's been the focus of my testimony. And it's that point, it seems to me various kinds of technical solutions need to be found. I mean, it's okay to have tile drains as long as there's a way of capturing the water or some way preventing it from going downstream, which may be challenging depending on the circumstances, but not impossible in all cases.
Representative Nelson.
So if you had tile drain show it and it hooked into an existing ditch, because you can't dump it straight into a brook, it's got to go into a conveyance before it hits a brook or stream. If you had tile drains that hooked into the existing ditch and then ran its way and did its thing, that could be okay.
Yeah, I mean, then it would flow for 2 miles through a public ditch and then discharge into a water body.
Yeah, that's typically or 100 yards or whatever.
Yeah, I can see people getting excited from a water quality standpoint, but not from, I think from a water quantity standpoint, that solution addresses the problem because you're not invading somebody else's property with extra water.
It's a public ditch along a public road. It's not physically altering the ditch. Representative O'Brien.
Although, I mean, this, once again, we sort of cross here where if we accept tile drainage as an artificial changing of the natural flow of water, and then we have a flood, which is natural, what happens then? Because then it's unusual amounts of water and could be a trespass.
Well, I think there's a natural hydrograph and then representing the water that's flowing across the property line of the person downstream, and it goes up and down and up and down. And then with the tile drains, the problem is that probably the peaks. It depends on the circumstances, but certainly the peaks are going to be much higher, and those are going to be and that increment is what's problematic, is that addition. And depending on the circumstances, there might be every time there's a significant rainfall, there might be some level of increment, but it's the high flows that are probably going to be the most problematic.
Perhaps with the tile drain, your soil is less at holding capacity. So when you get the big rain events, it has the ability to soak up more water, then slowly release it.
A good question for Heather Darby.
Yeah.
She's in on Friday.
Yeah.
Does anybody have any other questions? Well, thank you very much, John. This is really, we don't often get into the details of law, common law, or
Really great.
law, the way that we have with this bill. It's interesting.
Yeah, this is great. Thanks for getting us into the weeds.
What a privilege to be here. Thank you for the invitation.
Uh,
Seaweed.
we're all set for the day. We have,